Today I will be walking you through to the first incident that occurred during my journey and my first issues that I officially made complaints about at this point in time. So what I'll be doing is I will be reading the actual letter, but I have amended the names. I won't be using the names that is actually on the actual letter, but I will be reading what was actually written on this letter. So I will be looking down and looking up. That's because I'm reading. The letter is dated 10th of October 2006. It's got the employer's details. Dear employer, the union is authorised to act in behalf of the plaintiff in accordance with Section 236 of the Employment Relations Act. Plaintiff wishes to formally make known to you that she has an employment relationship problem. She believes that she has been treated unreasonably, unfairly, and has been discriminated against for some unknown reason by her manager. This letter is the first step resolving this employment relationship problem. Please find our written statement regarding the employment relationship problem. 1. Plaintiff disputes that manager provided her the supporting in regards to performance issues that she purports to have undertaken. During the times plaintiff had helped out in other jurisdictions, no one helped cover her workload. Colleague was unable to provide support as promised due to her own workload. Colleague was unable to provide the half day per week mentoring promised due to her own workload. Manager has provided no support or encouragement to the plaintiff. Manager fails to respond in the appropriate manner when plaintiff raises any work-related issues with her. For example, telling plaintiff that perhaps she should look for a job elsewhere. Number 2, plaintiff is of the opinion that manager has falsely represented plaintiff's workload. When colleague held the same position, her workload was considerably less than is expected of the plaintiff. When colleague held the same position, she encountered less interruptions such as phone calls, emails, or having to help out in criminal jurisdiction. When colleague held the same position, manager would help colleague when her workload was erroneous. Plaintiff is of the opinion that manager has actively undermined her, not allowing plaintiff to attend the monthly meetings with referees, despite requests from plaintiff and referees. Telling plaintiff that the referees had not wanted her to attending these meetings when in fact the referees had made requests to manager the plaintiff needed to attend. Providing false reports of negative verbal feedback from referees and co-workers. Treating her differently, less favourable than her colleagues, failing to acknowledge the plaintiff's workload, undermining her role as delegate by questioning her actions to members. In line with 4.52 of the collection agreement, plaintiff wants to first attempt to resolve this matter informally. Plaintiff is aware that her concerns will need to be verified and is happy for those concerns, such as co-workers and referees, be spoken to. We propose a meeting as soon as possible date. Yours sincerely, Union. There's a lot involved in this actual letter. We had a work relationship problem. The section that I was actually in, that this person was my manager from 2004. I was in this jurisdiction for about 4 years, from 2004 until I actually moved to the next jurisdiction, which was criminal. So what actually happened with this, it didn't go any further than when I had a meeting with the actual court manager at the time. The court manager received this letter. Regardless, the things that I had suspected was happening in the office was happening, and all I wanted to do was tackle the issue early and try and put a stop to it. And things was okay for a little while. That was the first time I made a formal complaint of my environment, my in-the-moment incident that took place within the workplace. So that's the environment that took place at this time. Employer's address. Dear Manager, I have reason to believe that you have been gossiping behind my back and have been passing personal information about me to people within and outside of the court, including certain members of my church. I need you to know that your conduct is a breach of the Privacy Act, and that any personal information about me passed to others needs my permission first. You have not complied with this, and therefore you open yourself up to having a complaint made against you in the Privacy Commission. Also, I want you to know very clearly that I will not tolerate your unprofessional conduct, and if there is a continuation of it, I need to make a formal complaint to the management on the basis that your behaviour is bringing the employer in disrepute. The union and the employer code of conduct prevents you from doing anything to me that would cause me distress. Also, the State Service Commission Code of Practice says that you should not be permitted to bully me. Your conduct has caused me serious distress, and I feel bullied by your actions. Therefore, I consider your behaviour a serious breach of the Code of Conduct. And if I am forcing to make a formal complaint, I would expect you to be disciplined according to the employer discipline guidelines. I need to warn you that I am keeping record of every instance of conduct which I consider unacceptable, and this will be used against you in any future information about me to those outside of my workplace. As an acknowledgement that you are taking this seriously, I would expect a written apology on my desk within 48 hours. A copy of this email and your apology will be passed to the manager for her information. Yours sincerely, the plaintiff. The person who drafted this letter up after speaking to him was a union representative delegate, and he and I drafted this letter up together, and with his advice and support, he told me to put it in email and then send the email out to the colleagues. This letter is what the report for the mental health report, where whoever wrote that report at that time had indicated that I've sent out threatening emails. But I did forward this letter to 3 colleagues, all 3 of them at once. None of them responded to it. I had discussions with the union in regards to this email and with the manager, who was the manager at the time. As far as my work environment, it didn't improve. And if it did improve, it was just a temporary thing, and then it sort of started up again. But why this letter is important, this is the letter that the court manager responded. So this is the actual email letter that was sent to them. Now, the other information that's really important about this letter, this same delegate that helped me out with this letter, and through that process of the cyberbullying that I was going through, his name was on the protected disclosure as evidence of my complaints, and in support of what I was that I'd gone to him. This person who helped me out write this letter, his name was also on the protected disclosure. The situation I was going through at this time, it was a very hostile, dangerous situation for one individual. And I didn't know what else to do with the criminal stalking. And in desperation, I needed help to have it, stopped. Unfortunately, that didn't happen.